Mr. Weinhardt.
Thank you, Your Honor. May it please the Court, Counsel. I'm Mark Weinhardt. With Todd Lance, we represent the defendant in this case, John Hoyman. Mr. Hoyman, the longtime outside city attorney to the city of Indianola, appeals his conviction and his 10-year prison sentence for fraudulent practices. We believe that the district court, in two very serious ways, misconstrued the fraudulent practices statute, and we'd like to talk about those things today, but the gateway issue, the threshold issue, is whether the district court should have sat on this case at all. The Iowa Code for Judicial Conduct states that a judge shall disqualify herself in any proceeding in which her impartiality might reasonably be questioned. Whether or not she failed to comply with that command, we submit, supplies the rule for decision in this appeal. In other words, if she failed to heed that code provision, then the conviction should be reversed. This court has used that code provision in a long line of cases dating back to 1976 as the decision rule for whether or not a lower court judgment should be reversed based upon the failure of a district court to recuse himself or to recuse herself. And the state does not really argue against the code's applicability here, but rather argues to some degree, well, it applies a little bit, it applies with some force, but doesn't really articulate whether or not it supplies the decision rule. We would commend, if the court has any doubt about this, the Nebraska Supreme Court decision in the Tierney case, which collects cases from around the country, cases all of which stand for the proposition that the Code for Judicial Conduct or its state court equivalent in those states applies to give the disappointed litigant in the proceeding below the ability to seek reversal and obtain reversal on appeal in the event that the district court should have recused and failed to do so. The facts in this case are amazingly simple. The district court's spouse and the prosecutor are extremely good friends, such that the judge and the prosecutor see each other in their respective homes.
Say extremely good friends. She said, actually, my husband is the one who has the friendship. We're not extremely good friends. And you had the ability to ask more questions if you wanted, right?
I had the ability to ask more questions, but I will say two things about that. The first is that the fact that 3 years before the trial, the relationship between the judge's spouse and the prosecutor was sufficiently close that the judge's daughter was the flower girl at the prosecutor's wedding is emblematic of an extremely close relationship without us needing to know any more facts. It's like the vacation between the judge and the prosecutor in the Murphy case, which we would submit is the case that is the closest to this one factually. The second thing that I would say about this is while I had the opportunity to ask questions, Comment 5 to the code makes it clear that the rule is not a rule of discovery by the litigants, it's a rule of affirmative disclosure by the court. It was for the court to disclose the relevant facts to the parties, and curiously, the prosecutor, who has equal personal knowledge of these facts, not only disclosed no facts on the to help illuminate the court's decision, but did not even say anything in resistance to our motion to recuse.
But now in reviewing the record, don't we have to go by what was stated and what was there and assume those things are true?
And yes, and I think what was there and what was stated is more than enough to cause disinterested observers, either in the legal culture or the lay culture, to have very real concerns about the appearance of the justice that was handed down in this case. And we all agree, and this court confirmed just 3 weeks ago in the Krull case, that that's the standard. It's not whether the judge subjectively believed that she could be objective, but whether or not the reasonable outside observer. And I would submit that if this set of facts, simple as they are presented to any group of disinterested lawyers or disinterested lay people, that most of them will blanch at the idea that the mother of the prosecutor's flower girl sat on a trial that the prosecutor was handling.
Counsel, to what extent does it make a difference that the judge's perception, or at least what she revealed on the record, was that the friendship was really between the prosecutor and her husband. Should that make a difference?
First of all, I don't think that it makes any difference because I think we treat marital relationships as being sufficiently close to each other that absent some fiduciary duty of confidentiality where husband and wife don't talk to each other, we assume that husband and wife communicate about everything important to them and that they are very closely aligned. That's the first thing. The second thing is that that might be a persuasive fact if it were part of some sort of analysis that the district court gave of this relationship. But the problem with the district court's handling of this is the district court didn't say anything at all about the relationship between herself, her spouse, and the prosecutor. She irrelevantly talked about a much different relationship with Mr. Hoyman, or the absence of one, and whether or not our children go to the same school with each other. So she really did not exercise her discretion at all, both in that way, and she got the standard of review backwards. She said that her duty to sit on the case trumped her duty to recuse if there was a relationship problem, when the code clearly says that those are the other way around. And in the Kroll case 3 weeks ago, this court said that even in a rural county where there is an absence of lawyers and judicial officers, the duty to sit always takes a back seat to the duty to recuse.
Counsel, assuming that she was required to, the judge was required to recuse herself, where did the prejudice surface at trial to require a new trial at this point?
There are a couple of different answers to that question. The first is this court to date has never required a showing of trial prejudice in order to require reversal. The Harry case is the case that stands out, in which this court reversed a criminal sentencing, conceding that it is likely that a different judge would have given the same sentence and that the defendant got the sentence that he expected, but nonetheless, because the appearance was improper, there needed to be a reversal. In other words, this court took the position there is no harmless error.
Well, this comes before us on a motion for a new trial based upon the failure to recuse, correct?
Correct.
And then doesn't the defendant have to establish prejudice to achieve a new trial?
That is actually for this court to decide. If this court follows the rule in Harry, no, it does not need to find prejudice. If it adopts a prejudice standard, we would submit that it should follow the majority rule across the country, which is the three-part standard in the Liljeburg case from the United States Supreme Court, which considers prejudice to the litigant, but before that, and hierarchically, considers prejudice in the form of concerns that the public and the bar would have about whether justice would be done, number one. Number two, whether or not the decision in this case will have an effect in either squelching or promoting injustice in other cases. In other words, what will be the deterrent effect on other judges? And finally, number three, what was the effect on the individual litigant? But to get to where the court is going.
Hasn't our court abandoned the prejudice in the Forsmark case, that you don't need to prove prejudice?
That's our opening position, Your Honor.
We've said it in 1984 that you don't have to show prejudice.
And that case and the Harry case, we think, go hand in hand, and we would agree with that analysis. But if this court is looking for prejudice, I will give just two examples, Your Honor. At the sentencing in this case, the district court, as an aggravating factor, said, and this is at page 417 of the appendix, that Mr. Hoyman billed for work that he did not do in regards to other items in addition to traffic prosecutions. That, Your Honors, is made up. There was no evidence at trial that suggested that. In fact, the prosecutor never asked for that finding. That finding was absolutely composed out of thin air by the district court. Secondly, more than 50 people from all walks of life gave glowing character recommendations for Mr. Hoyman, either at trial or at the time of sentencing. And the district court turned that into an aggravating factor against him instead of a mitigating factor. In more than 25 years as a criminal lawyer, I have handled hundreds and hundreds of sentencings. I have never seen that happen. We believe real prejudice happened.
Before your time runs out, can you get to the merits about whether or not the instructions were proper? And
I would be happy to, Your Honor. The fraudulent practices statute contains the word in the criminal setting false. We believe that in that context, false contains not just the attribute of incorrectness, but false contains an intent to deceive someone. And intent to deceive was the thrust of our defense here, and it was taken out from under us when the prosecutor held up the jury instruction for fraudulent practices and said, that word deceived isn't here.
Couldn't the legislature criminalize something less than an intent to deceive just by signing a false statement in a public record? I know your brief is full of absurd things, and I'm going to be careful now if that's right, but couldn't we find that the legislature criminalized just making a false statement in a public record?
The legislature could criminalize making an incorrect or an inaccurate knowing statement in a record, but for it to do so and denude that crime of a requirement of intent to deceive, I think the legislature would have to do two things. First of all, it would have to use something other than the word false to describe the conduct, and secondly, it would have to put it in a context other than a statute called fraudulent practices.
Titles, we've held the titles don't control what a statute is, but tell me what other word they could have used that would have been the statute that you claim it wasn't. Does that make sense to you?
No, I understand exactly the court's question. It could have used incorrect, it could have used inaccurate, it could have used wrong, but we believe...
untrue.
It could have used untrue.
But a pretty narrow path you're trying to navigate. I understand your point that there's no materiality element here, which
right.
I guess is unlike the
Which is
federal
unlike 1001 in the federal criminal code. That's right.
And that gives it extraordinary breadth if we don't read an intent to deceive in it. Is that your
right?
position?
And I think context really matters in terms of how one uses a word like false. I would commend to the court Yates versus the United States, which was decided 2 weeks ago today, that had to do with what the word tangible object meant in the context of a federal obstruction of justice statute, and having to do a lot more work than this court has to do with regard to the word false. 5 justices of the Supreme Court found that tangible object in that case was limited to objects that contain information, that the undersized fish that got thrown over the side in the Gulf of Mexico was not a tangible object. We think the same kind of analysis, but really a much simpler analysis, occurs here. The state has not presented the first authority, not a case, not a commentator, not anything to suggest that the legislature intended untruth or incorrectness as the wide breadth of the fraudulent practices statute. And to talk about the breadth for just a moment, in the nonprofit, business, and governmental worlds, millions of documents are prepared, sent, and transacted in this state every year. And the idea that one of them would become felony criminal because somebody, knowing that it contains a factual inaccuracy, but they just don't have time to go back and look it up in the files to correct it before they send it to the boss. The idea that that person is a Class C felon and can get 10 years in prison, that's not what the legislature is likely to have intended when it passed this statute. I would like to then just very briefly turn to the other statutory error in this case. The aggregation statute that was relied upon to make this a Class C felony instead of no higher than a serious misdemeanor starts with these words: if money or property or service is obtained by 2 or more acts. That's the threshold word, the concept that Mr. Hoyman had to obtain something. The district court's construction simply read that word out of the statute. It turned the rule of lenity, which we think controls both of these questions, absolutely upside down. This court in the Anderson case said that provisions establishing the scope of criminal liability are to be strictly construed with doubts resolved in favor of the accused. Despite saying she struggled with the word, the district court dispensed with the word, and that was reversible error.
Thank you, counsel. Mr. Hanson.
May it please the court. Speculation is not sufficient to require recusal of a judge, and it's not sufficient to require reversal of a conviction in absence of a prejudicial disqualifying relationship.
How do you get around Forsmark with your argument here? And are you familiar with the case?
I did not run across that one. I don't believe it was cited by...
What happened in Forsmark is that the judge was proceeding in a case, I think in Boone County, and one of the witnesses in the case happened to be a doctor that the judge's brother was suing for malpractice. The judge failed to disclose the fact of that relationship, and that came up after trial. What our court said, plain and simple, we probably don't think there would be, the judge would have to recuse himself with that relationship, but we're not going to litigate that. We're going to reverse it without showing any prejudice for the mere fact the judge failed to disclose that fact without showing of any prejudice. So when we're dealing with this statute about reasonably, what the public will think, we actually set aside a whole malpractice trial after the judge even failed to disclose it with showing of no prejudice and actually of showing that the judge didn't have recusal. So I don't know how you can ask us to put a prejudice thing unless you're going to have us overturn a case like that.
Well, we have to look at the purpose of the rules. It's not a case where, and I'm not sure what the basis of the recusal issue in that one was, but here the defendant is basing his recusal request on the Code of Judicial Conduct, and the code says it sets forth the highest standards of judicial performance, which is perfection. And we don't demand perfection in trials. The defendant's entitled to a fair trial, but not a perfect one.
I don't know. You all you had different arguments, a series of arguments in your brief. It struck me that your better argument is, even if we apply the Judicial Code of Conduct and even if we assume reversal for prejudice, all that was on the record here was a friendship between the judge's spouse and the prosecutor, and that's not enough. Isn't that a better argument?
That's absolutely true, and that's what I submit the court should decide this case on. And the problem is, as I started with, it's speculation. And Mr. Weinhardt says it's a simple case. What really happened is it's an undeveloped case. And I would wonder if this set of facts had been presented in a judicial qualification case, if this court would seriously consider blemishing this judge's record based on such an underdeveloped set of circumstances here. All we know is the judge has a husband who's friends with Mr. Sand.
Hey, underdeveloped, implying there's something else out there. I think you're not giving the district court enough credit. Judges and lawyers are friends all the time. The Murphy case was an extreme case where they were about to go on a vacation together, right?
Yeah, and they actually did go on the vacation together, I believe, yes.
But counsel, this is more than just a scenario in which the judge's husband is a friend of the prosecutor. She did reveal in this case that they socialized in each other's homes. So, I assume that meant that not only her husband was socializing in the judge's home, but she too. And doesn't that create a rather troublesome image for an objective viewer?
No, it doesn't, because as soon as she said, or as soon as she disclosed that they have seen each other in each other's homes, she emphasized that she has no relationship with Mr. Sand outside the context of her husband. So it really leaves the door open to speculation. Does that mean Mr. Sand came to her house and just went down and played pool in the basement with her husband? Or does that mean they had some sort of more intimate setting or circumstance going on? And that's what Mr. Hoyman's argument relies on, is a very general, non-specific fact of a social relationship, and then leaving it to what he calls inference, which is really just speculation about how far that relationship really goes.
Well,
and whether
in fairness to Mr., as far as who should have developed the record, I mean, personally, I think we know what we need to know, but, I don't see a need to recuse here, because I think there's a difference between friendship with the defendant or a party to the case and friendship with just an advocate, spouse, not you personally. But Mr. Weinhardt needed to inquire to know what he needed to know to ask the court to recuse, because a lot of times this comes up, the judge discloses something, and the parties confer with their client, say, we don't have a problem with that, Your Honor. Mm-hmm. And he learned enough to seek recusal. But didn't in Kroll we make clear that the duty to sit requires the judge not to recuse if they're not required to? If there's not a valid reason to recuse, we want them to sit, right?
That's correct. And that's because the Code of Judicial Conduct is not intended to create collateral sort of benefits for people to get to judge shop around until they find somebody that they like.
This case happened in the 5th Judicial District, which has probably the most judges of any district, and they're pretty fungible, at least when I practiced they were, and I think they pretty are now. It wasn't a case where there was no judge available to take over the case. This was disclosed almost a week before trial. In fact, as I understand it, she just got the case the night before reading the stuff. Where is the duty to sit when you have all those facts dealing with there are other judges probably available?
And I think the size of District 5 underscores the fact that even with all those lawyers, all the judges, luck of the draw, we found a judge who knows both attorneys in the case. And I don't think we can speculate that we could just go down the chain and find somebody who
Two
has never
recused already for that reason. Two recused before that for the reason that they knew Mr. Hoyman, I think. I think didn't Judge Kimes and someone else recuse themselves?
Yeah, that's right, because they intended to testify at trial, yes. But because there's so many lawyers, so many judges, and we still found one who knows both lawyers, I think it's going to cause problems, especially in districts that aren't.
This is more than knowing both lawyers. I mean, I know lots of lawyers sitting here. Doesn't mean I recuse myself. There's a little more to it than just knowing the lawyer.
But that's all that was proven in this case. He has this attenuated connection between her husband and the prosecutor, but there's absolutely no proof that there's a close connection such that any impartial viewer, knowing all the facts, would question her impartiality.
Don't you think the public's view of the judicial system is as important, if not more important, than the duty to sit, especially in a case where there were plenty of judges available?
Well, and again, I question whether we can say there was plenty of judges available, because if we required her to recuse in this case, then what happens when it's a smaller district with fewer judges?
Recusal's fact specific, and this not a smaller district and not fewer judges available, and that seems to bother me a little.
Okay.
Why shouldn't I be bothered by it?
Because there's nothing here that a reasonable person, knowing all the facts, would find troubling. It's not uncommon for judges who are lawyers to know other lawyers, and that fact alone should never be sufficient to require a judge to step aside.
Can I move to the fraudulent practices issue? As I understand it, Mr. Hoyman's defense was basically, and if I'm not summarizing the facts inaccurately, I'm not summarizing them accurately, don't fight me on the facts, please, just
Okay.
answer the question. All right, I get to do that as the judge.
Sure.
All right, so, as I understand his defense, it was basically I worked the total number of hours or more hours than I was actually claiming, but I put entries in different categories, and they knew that I was putting them in different categories, and all they cared about was the total hours, and the total hours were correct. And the jury at least accepted that somewhat in part because he was acquitted on the theft charge, right? So is it your position that the legislature criminalizes any entry that's incorrect in a public record, even if the recipient of the public record knows that it's incorrect?
That's how the plain language of the statute reads, yes.
Doesn't that lead to all those strange and absurd results that Mr. Weinhardt mentioned in his brief?
First, two parts for your answer. First is the legislature can reasonably prohibit any false statement in a public record because the law gives special consideration to public records and to business records. For instance, the relaxed evidentiary standard for hearsay. So that's reason
The
in
governor
itself.
would sign one of these official decrees and put a false statement in there and sign it, he's guilty.
A knowing false statement.
Yeah, he signed a decree for somebody, and it really doesn't affect anything, but he puts the so-and-so society is the best society in the world, and all these things in there, and if it's false, and he knows he can't verify what's in there, so he doesn't know it's true, is he guilty of the crime?
Well, I mean, that example is a little, I mean, that's a matter of opinion what the best society is, but the plain language of the statute would say that. And the problem is we're delving into the absurd results doctrine when it's not needed. And if the problem is the statute is overbroad, let's wait until
Problem in
somebody's
this
caught
case,
up
he
in an
was
absurd result.
acquitted of a crime that involved the intent to deceive and the intent to steal, and that's the problem. And this seems to be the perfect case to figure it out, because we know what would happen probably if that element was there. So, I mean, we can say it's here, and then when you get one of these absurd cases, we say, well, they really didn't mean to criminalize that. And that's not our job.
Well, and now I hope I get the opportunity to address the facts. Sure.
To answer his second question, I interrupted,
Okay.
I'm sorry.
Well, the facts don't support that Mr. Hoyman had permission to write false names and false amounts for the prosecutions he performed. To the contrary, the clerk said, if I knew there were false names in there and false hours, the city never would have paid them. And in fact, I think, and this is the crux of the problem with the false statement, is Ms. Bolin, the city clerk, worked in City Hall, and she knew what was happening with the so-called below-the-line expenses, the civil type work that Mr. Hoyman was doing. So she had the ability to exercise oversight on the reasonableness of his charges for that. The prosecutions, however, occurred at the courthouse, where there were no city employees to oversee Mr. Hoyman. And he knew that. And he knew that that was a way to exploit
But
a
what you're
weakness.
saying is, what you're telling me is that if the trial judge had given that intent to deceive instruction that Mr. Weinhardt requested, the state still would have gotten a conviction, right?
That's correct. And
So what's wrong with that? Why shouldn't that be? I mean, one common understanding of false is that it implies deceit. I mean, it's kind of a strong word. We don't normally accuse people of saying things falsely unless they intended to deceive, right?
no, and false can mean incorrect or untrue or any of those other synonyms. In certain circumstances, it can mean, in a criminal context, the intent to deceive. But that's only if the legislature hasn't already articulated a mens rea element. And here they did so. They said, knowing the document to be false. Not, And if they hadn't included that, then I think we'd have a much different argument about what the meaning of false is. But when the plain language of the statute says false, the legislature's spoken about the mens rea element that the state has to prove. And there's no room to infer in a different or an additional mens rea element based on a supposed ambiguity in one word.
Were there jury instructions incorrect requiring a new trial by omitting the word obtained or that concept?
Well, first of all, the case, the McSorley case says you don't have to obtain anything of value to commit fraudulent practices. Despite that, Mr. Hoyman got the benefit of an instruction requiring proof that he obtained something. And if you look at the instructions, I think it's 25 and 26, they almost exactly follow the language of the code. One says it's fraudulent practice if more than $10,000 is involved. The very next one defines what involved means, and it included the obtained language. So because those instructions were correct, the state asks that this court affirm.
Thank you, Mr. Hanson. Rebuttal?
Thank you, Your Honor. I'd like to go in the reverse order of the discussion of things to just briefly talk about the word obtained. Justice Waterman, I think that the state misuses the McSorley case. The McSorley case, neither on its facts nor as discussed by this court, was a case depending on the aggregation statute. And McSorley's argument was very different from Mr. Hoyman's argument. Mr. McSorley's argument was the word involved really means the word obtained. Our argument is the word obtained means obtained, and the district court erred by reading it out of the statute. With regard to the mental state required for fraudulent practices, to follow up on Justice Mansfield's question, when the district court omits an element as it did here, it is a problem of constitutional magnitude. It deprives the defendant of his Sixth Amendment right to a jury trial. It is no place for this court to be talking with either of the lawyers about what the facts were unless the state can demonstrate, which it did not attempt to do in its briefs or in its remarks here, that the error of depriving the defendant of that element was harmless beyond a reasonable doubt if, and that's if, this court follows Nader versus the United States. In the Schuler case, Justice Appel will recall, this court reserved the question of whether it can ever be harmless error when an element is omitted from a jury instruction. And so we are not here attempting to engraft a new element, but rather that element, the intent to deceive element, was always present in the presence of the word false. Now, we are not trying to get the court to decide the case based upon the absurd results, although Justice Wiggins' example about the governor is exactly right, and if the statement is one of fact as opposed to opinion, it absolutely would be criminal under the construction advocated by the state. But we also don't need some sort of constitutional standing in order to invoke absurd results as a way to tell the court how to construe the statute in the garden variety of cases, which is what this is. Standing requires that the person was specially harmed because of the extreme exercise of the statute. But what we're simply arguing is that in all cases, the statute contains a plain requirement based upon the existence of the word false. Now, if this court reverses on either of the two grounds that I have just described, the minimum that it should do with the recusal issue is remand this case for a new trial in front of a district judge different from the one previously assigned, so that that way both the public's faith in the system is preserved and so that we're not back here having this conversation again in a year in the event that Mr. Hoyman were convicted on a retrial. We've cited in our opening brief authorities for exactly that result if there is a reversal on another ground. We do believe, however, that there should be a reversal based upon the recusal ground. This is not a situation in which the district court rendered a reasoned analysis of her own relationship with the prosecutor and her husband's relationship with the prosecutor, and then in a careful exercise of her discretion rendered an opinion that is due any deference. Instead, her abject failure to deal with this situation is exactly like the Forsmark case, as Justice Wiggins described it, but is also like the Bride versus Heckert case that this court decided, and like the Villardo case decided by the Vermont Supreme Court. In all of those cases where there was a failure of disclosure or a failure by the court to render a reasoned decision upon the recusal question, the result was the same, and that is a reversal and a remand for a new trial in front of a different judge. That's what should happen here, not just because of the troubling relationship, but because of the troubling way in which the district court described it. And I would, with due respect, say I think this case is exactly like Murphy, because the role that the flower girl in a wedding occupies in this society is extremely, extremely significant, and more significantly than that, it strikes the ordinary Iowan as very significant. And so the ordinary Iowan hearing these facts is going to have concern about whether or not justice was done. If this court looks at the Murphy case and just substitutes Flower Girl and the relationship that she symbolizes for the vacation, I think the court gets to the same place. Although the court need not go that far just by looking at the Moran case from the Eighth Circuit, because that did deal exactly with what we know goes on here, and that is the reciprocal visits between the lawyer and the judge in the case.
On the false intent to deceive, if false can have several meanings, one that requires an intent to deceive, one where a simple inaccurate or untrue, is your fallback argument you win under the rule of lenity?
That we win under the rule of lenity, but that we also win because the word false in the context of a criminal statute means the more severe meaning than it does when we're talking, say, about a true-false test, just in the same way that tangible means something very obvious in one context, but it means something different in that federal obstruction case in Yates. Thank you very much, Your Honors.
Thank you as well, counsel. The case then is now submitted, and we'll take a 5-minute recess.